Right now we have Matthew Pokarier and Stefanie Luhrs from Clyde & Co. talking about the first 12 months of the national data breach legislation and what's changed, how things have actually gone on. Please hold your questions to the end, and if we've got time, we'll have them then.
Thank you. Thanks very much. Welcome, everybody. I'll very briefly just outline what we're going to go through, and then we'll get stuck into it because we've got quite a lot of material to get through. Steph is going to take us through the Australian regulatory landscape in a very brief way, just as a refresher, so it puts sort of what's happened in the last 12 months in some context. We'll look at the key takeaways from the Office of the Australian Information Commissioner's Ndb Scheme 12-month report. This is the sort of first real large data set we've had a chance to have a look at as to how the whole regime is working. We'll then look overseas, we'll look towards Europe and the Gdpr statistics, key trends and misconceptions. We'll look at key trends arising from notifiable data breach generally, some common incident response issues and privacy implications that we've seen, and then future trends and issues.
Thanks, Matthew. Just to recap on some of the key requirements under the Ndb scheme. Firstly, who does it apply to? Well, the rule of thumb is that it applies to Commonwealth government agencies and organisations which have an annual turnover of more than $3 million annually. But do remember that some organisations that have an annual turnover of less than that can still be captured. There are a number of carve-outs under the Privacy Act that mean small businesses can be captured. What to investigate? The number one question we're asked is, do I need to notify? And the answer is always, well, first we need to understand, has there been an eligible data breach? And you need to do that assessment within 30 days. There are three key questions we go through when initially judging. Has there been a data breach? I might just stand here, sorry. To answer that question, you really need to look at, has there been any unauthorised access to or disclosure of personal information? And that's where forensic vendors really assist us. They help us to map out the path of the threat actor whilst in the system so we understand what personal information has been affected. The second question is serious harm likely? The risk of harm assessment is a really difficult exercise. So take, for example, an email address or a name may be considered to be relatively benign information, but if you think of it in the context of an Ashley Madison type of breach, well, in those circumstances, a name or an email address would have a serious risk of harm. Remember that harm includes not just financial loss, also emotional distress. The third question is, can remedial action be taken to prevent the likely risk of serious harm? In most cases, there's little that can be done to do this. Threat actors have been in systems for months before the incident is made known to the organisation. But if, for example, there's been a misdirected email, can you just pick up the phone, ask the recipient to delete the email? In those cases, the likely risk of harm is removed. When to notify? You need to notify as soon as practicable. This doesn't mean on day 30 of your investigation, but it means acting quickly to notify once you've determined that an eligible data breach has occurred. You need to notify the OIIC and affected individuals at risk of serious harm, and there are penalties under the Act. The upper limit is currently $2.1 million, although the government's recently introduced or proposed its intention to bring in some tougher penalties. So the proposed amendments include an increase in the maximum penalty from $2.1 to $10 million, or 3 times the value of any benefit obtained through the use of the information, or 10% of a company's annual domestic turnover, so whichever is the greatest. Those proposed changes will also be backed by increased powers to the OIIC to issue infringement notices, which will be backed by penalties of up to $63,000 to companies and $12,600 for individuals who fail to cooperate with efforts to resolve only minor data breaches. So notwithstanding those proposed amendments, the OIIC in the last 12 months has really been adopting a conciliatory approach in working with entities that have been affected by data breaches. So we'll be monitoring with some great interest over the next months and year as to whether or not the OIIC might alter that stance and take a harder stance.
Okay, well, let's have a look at what the findings are of the last 12 months. Now, in total, there have been 694 eligible data breaches. And on top of that, there's been 168 voluntary notifications from 1 April last year through to 31 March this year. Now that's a whopping sort of 712% uplift on notifications when compared to the previous 12 months. It's worth noting that the voluntary notifications capture a class of notifications that either the organisations involved aren't caught by the Privacy Act, or the particular breach doesn't meet the definition of an eligible data breach. What the Commission's doing in those circumstances is it's not allowing the organisation to remove the notification. It's merely recorded as a voluntary one. Now, what are the causes of data breaches? 35% is pure human error, 60% is malicious or criminal attacks, and 5% has been system failure. Now, most malicious or criminal attacks were attributed to vectors that you'd be very familiar with: phishing, malware, ransomware, brute force attacks, and involve compromised or stolen credentials and other forms of hacking. These also, of course, involve a human element. So the human element component of this is more than the 35% referred to in many cases. It's a much larger number. In terms of the sectors most impacted, it's probably not unsurprising to know that health and finance reported the most data breaches. The rate of human error was also higher in both of those cases. In health, the human error component was 55%, not 35%, and in finance it was 41%. The level at which they're reporting is probably not unsurprising. The Commission also notes that these are two sectors that record a lot of personal data and sensitive personal data. They're more mature in their management of that data. They're more aware of when they're breached, and they're more likely to report it. The number of individuals affected by breaches has been relatively low in 83% of cases. The number of individuals affected has been less than 1,000. That's likely because so many of these breaches resulted from human error. And in that case, a threat actor may have only gained access to a single mailbox or to a single part of an organisation. So only so many individuals were affected. I mean, where you see, I think, the much larger cases of very large numbers of individuals impacted, it's where you've had sort of multiple breaches, and where the organisation involved is a supplier to a number of other organisations. It's worth looking at the sorry, thank you, Steph. Now looking at the type of information involved in breaches. The Commissioner's report acknowledges that most of the community is pretty much on all fours with the fact that serious financial harm can result from credit card information being stolen, or from identification information like passport information, health cards. Everyone's pretty much aware that that can cause a problem. And can really cause someone some serious harm. There's less awareness in the Commission's view of the fact that just general contact information can also lead to that sort of harm. And as we see on this graph, contact information is the largest form of information that has been accessed. The OAIC has really highlighted the need for organisations to assess the potential for serious harm in the context of personal information that's been involved in a data breach. Now, Steph was talking about the fact that this simple information can appear innocuous, but if you're in a class of people who are quite vulnerable, someone who may be trying to avoid their address being known, is out of contact because they're involved in like criminal proceedings, they may be a protected witness, it may be a spouse trying to escape a violent spouse. So in those circumstances, quite banal information can lead to serious harm. It also, of course, in the hands of threat actors, can improve the effectiveness of phishing attacks and other social engineering attacks. So it's important to be conscious of the fact that even quite simple information can lead to harm. The average time to notify the OAIC, I mean, month by month it jumps around a bit, but I think what you can see there is a general trend, a general increase. Why is that? From our perspective, what we're seeing is complex attack vectors, meaning as incident response managers, we're having to bring on forensic people to have a closer look at what systems have been accessed, how that's been done, and what sort of data sets have been impacted. And that takes time. Additionally, the data sets involved are more complex. They can involve different categories of individuals, and they may involve differing communication strategies in how you deal with a breach. So that is also taking more time. So I think we can understand how that slow increase in time of notification is occurring. The type of cyber incidents that are occurring in all sectors, it probably comes as no surprise that phishing and spear phishing are the most common and highly effective methods by which entities are being compromised, whether they're large or small. Threat actors obviously typically use phishing to elicit credentials, usually a name or password, and gain access to the system that way. In many of the matters we're dealing with, they've involved the use of the WeTransfer phishing link, which provided subsequent access to clients' Office 365 accounts and the whole environment. I mean, after phishing, the next most prevalent cyber incident also involves compromised credentials, where the method of compromise was not known by the entities who were reporting. So again, we see this real interest in credentials. The Commission's of the view that this is due to the growing prevalence of credential stuffing. There's been some reference to this in a number of papers during the course of this conference. And in recent years, huge troves of confidential credentials have been repeatedly posted online by hackers, and it's typically aggregated from previous data breaches. Now, this is working because people reuse usernames and passwords across multiple accounts. So I think, again, we're seeing that reflected in just the numbers from the Commission as to what these threat actors are looking for and what they've been harvesting. We talked about human error breaches being a critical issue across all sectors. I'm not going to run through each of those elements because I think they're pretty obvious, and you can have a look at that yourself. The only message I would take from that is the importance of training and the importance of education to reduce the extent to which these sorts of breaches occur. This is certainly something the Commission's referenced and has really highlighted the need to attend to this. Now, the regulatory landscape. What's the regulator been doing from a pure regulation perspective? Steph had mentioned in the area of penalties that the Commission is taking a very soft approach at first and a very conciliatory approach. Over the past 12 months, they've been really trying to drive awareness of entities' obligations and the causes of data breaches, and to support better practices across industries. Now, the OAIC reports that they've been very happy with the organisational response to that. They've seen people quite prepared to engage very proactively about it. I suppose as a result of that, we've not seen any major sort of enforcement activity by the Commission or penalties for failure to comply with the Ndb scheme. There's an ongoing discussion about how this regulatory framework should work. It oscillates between a carrot and stick perspective. The issue is, should it really be managed by ongoing collaboration between the community and the Commission, or should it take more of a hardline regulatory approach? The Federal Commission has come down on the side of saying, well, it sort of depends. It lies somewhere between both of these approaches. The Commission said they want to work constructively with organisations, as they have to date. They want to, build better protocols and ways of responding to breaches, and they're going to take a proportionate and evidence-based attitude to regulatory action. But they will be exercising regulatory and enforcement powers where necessary. I mean, the increase in penalties signals to some extent a signal from government as what they expect the regulators to do. We've seen criticism in the financial industry of regulators, so I think the Commission, while being fairly touchy-feely at this stage, will be prepared to reach for the tools if they feel they need to. The OAIC also has power to conduct an investigation where there are serious concerns about an entity's compliance with the privacy principles. We haven't seen this in practice as yet, but I think this is a mechanism they will turn to over the next few years. In one case, the Commission has reported that it's issued a direction to compel notification where it uncovered a failure to notify individuals. It's also reported conducting regulatory inquiries to ensure that breaches were contained and rectified, and that measures were implemented to prevent reoccurrence. So it is taking some regulatory activity, it's just being pretty soft about that at the present time. One thing the Commission is focused on, and we're seeing a little bit of this reflected globally, is the whole issue of consents provided by individuals to use their personal information. Organisations need to make it easier for individuals to understand the terms and conditions that are associated with those consents. And this is obviously very relevant in the social media environment. It was reflected in the Cambridge Analytica matter in July last year. And since that time, we've seen a representative action launched under the Privacy Act on behalf of over 300,000 Australian Facebook users. You will all be aware, I think, of this involved the harvesting by a third party of over 50 million Facebook users' data to use in election campaigning. The thing that I suppose concerns us as lawyers in this issue is there's not been any value, if you like, set upon your personal information if it's been used in this context. What the complainant's trying to do in this case is say that $10,000 is a nice number for what someone should be compensated for if they lose, if someone uses their data in this way, and it would be a very good deterrent for anyone who misuses the data in that way. Of course, the bill for that would be $3 billion if this gets up. So we're watching that very closely. The Commission's well advanced in that, and we'll see what comes of it. The 12-month report has provided some best practice tips, and when the Commissioner gives tips, it's always a good idea to take good notice of them. We've already alluded to the fact that human error is a major source of breaches, so it comes as no surprise that training is a critical element. Staff need to be trained to protect their devices and their accounts. They must also understand how to detect and report email-based threats, phishing being such a major part of data breaches, and understand basic account security. And there's been some discussion about passwords at this conference, and that's an advancing area. Preventative technologies and processes are essential. Investing in better security measures. The Commission refers to multi-factor authentication as something that should be used in conjunction with other education in mitigation against compromised credentials. Encryption and secure data transfer for everyday communications. Other enhanced security measures might include capture and identity verification checks. It's very important to proactively monitor systems, and organisations really need to review their data. It's quite important that you minimise the data you take, and if you don't collect data or maintain data that you don't really need. Being prepared is always important. Do you have a data breach response plan in place, and has it been tested? The Commission certainly expects that you will. At a minimum, it should provide practical guidance on how to respond to and reduce the impact of a breach, and to meet the obligations under the Ndb Scheme, and support individuals to reduce harm. And it's important, obviously, to have regular practices and exercises or data breach simulations to make sure that plan's working. Assessment of harm is critical. I mentioned before it's important to know your data, not collect what you don't need, but it's also important to do some data mapping. So you ensure you're able to make a prompt and thorough assessment of a breach that occurs. Most organisations should have the capacity to have some awareness of what harm may be suffered if that data is breached. And it's certainly entities that understand their data best are best placed to assess whether it's notifiable or not. Post-breach communication is something the Commissioner has focused on a bit. It needs to put the individual first. Too much of this can be quite defensive. It should communicate in plain English and provide practical information that helps people actually mitigate harm. The Commission reports that consumers respond obviously most favourably when it provides them with practical and real solutions, and so that can be a bit of a PR win for any organisation that's breached. It might be necessary to structure your notification campaign such that different categories of affected individuals are treated differently. That's particularly the case with vulnerable individuals, there might be children, elderly people, there can be quite a broad range of those. Also, and this is a very practical thing, consider the impact of timing of the notification. The Commission's warned against issuing notifications on a Friday afternoon or just before a public holiday, where you get to really raise someone's stress levels and create panic, but there's really not much anyone can do about it over the next few days. It's being sort of considerate and practical about that approach. Now, looking at some key takeaways, harm minimisation, I've talked about that before, I probably can't say enough about that issue. The Commission expects organisations to put individuals first, so communicate plainly and provide help in mitigating harm. Navigating multi-party breaches has become a bit of a challenge. There's been some confusion associated with this. There needs to be more coordination. You can have multiple entities who look after people's data. When a breach occurs, who notifies? Well, the simple answer is it's the entity with the most direct relationship with the affected individuals should do the notification. By way of illustration, in the PageUp matter, which happened quite recently, the Commission received more than 50 notifications from PageUp and its corporate clients in relation to that incident. So that's a huge, administrative task and can create some confusion, whereas if you have coordination with the party who notifies, it works much more smoothly. It's also important for organisations to be aware of the thresholds across other jurisdictions, because these breaches can cross borders, and there needs to be a focus on, if you're doing work in Europe, what the Gdpr requirements are, and also throughout Southeast Asia there are different regimes. Steph will now take us through Europe.
Thanks, Matthew. So happy first birthday to the GDPR. It's been 12 months since the GDPR first came into effect, and so there's been some lessons learnt over the last 12 months. But just to quickly recap on some of the key requirements under the GDPR, I'm sure many of you will be aware of these, but it'll be helpful to give context to the examples I go through later. Of course, the General Data Protection Regulation in the European Union. Thank you for that question. I hope there are others in the room that are aware too. There are tougher penalties, certainly under the GDPR. There are fines of up to €20 million or 4% of annual global turnover. Mandatory notification is also a requirement, so organisations are required to notify regulators within 72 hours and to affected individuals with undue delay. There needs to be a lawful basis for processing data, and this is a key issue under the GDPR. So there are 6 lawful bases for processing data. We usually hear a lot about consent, but there are five others that you can consider. So those include where there's a requirement to fulfil or prepare a contract, where there's a legal obligation, where there's a vital interest, so in a medical situation, for example, where there's a necessity to carry out a public function, and where there's some other legitimate interest. Individual rights are also enhanced under the GDPR, so those rights include the right to be forgotten, the right to data portability, and the right to access. The accountability principle has also been introduced. That's a new data protection principle that simply requires organisations to take responsibility for the data that they hold and to be able to demonstrate compliance with the GDPR. So if you're taking steps to comply with the GDPR now, make sure you're documenting that. Privacy by design is also now required under the GDPR, and there's a new definition for consent. So it requires positive opt-in and explicit consent for sensitive categories of data. If you're relying on consent as a precondition of service, then in those circumstances, it's not likely to be the best lawful basis for processing data. So where are we 12 months in? 89,000 data breach notifications have been logged to the EU regulators. 144,000 queries and complaints have been reported, but that really just confirms the perceived rise in awareness around data protection rights more generally. As to penalties, 11 of the EU regulators have issued fines totalling around 56 million euros, but do keep in mind that that figure includes the 50 million fine that was issued to Google in January this year. Some regulators have been more active than others. The French regulator has been particularly active, but that's likely because it's had to deal with Google and has issued the fine there. The UK Information Commission has also been particularly active, but a lot of the commentary that we're seeing at the moment is around fines and penalties that were issued under the Data Protection Act, which precedes the GDPR. So the ICO actually has a massive backlog. They're looking at investigations from 2017 still. I think last week they brought their first action under the GDPR, and that was against the UK Tax Authority, and they ordered them to delete 5 million voice records that they'd collected without valid consent. Just some key trends under the GDPR that have been identified by the key regulators. The French regulators experiencing a number of complaints relating to the right to be forgotten. So a number of people are making a request to have their URLs delisted, any names, contact details or photographs also removed from the internet. The Irish regulator has also experienced a number of complaints around the access issue. So a lot of those complaints might involve where an organisation has taken too long to respond to a request for information. There's a 30-day timeframe under the GDPR. And there's also some popular use of the right to data portability by bank customers. So what have we learnt from the fines and penalties that have been issued over the last 12 months? Firstly, and this is really no surprise, but quick response and notification will help to reduce fines. So in Germany last year, the personal data of approximately 300,000 social media users, which included their passwords and email addresses, were compromised. No surprise that the users' passwords in this case were in unencrypted form, and the regulator said that this is a violation of your obligation to implement adequate security measures. However, in this case, the regulator imposed a reduced fine of €220,000 on the basis that there was quick notification to the regulator and that data subjects were also notified quickly, and because there was cooperation by the organisation in responding to the regulator's recommendations within weeks of the breach occurring. Secondly, deliberate conduct will likely result in high fines. So Google is a case in point here. To recap on that matter, the French regulator fined Google €50 million for collecting personal data from users without providing an adequate level of transparency on how that data would be used for personalised advertisements. Google actually appealed this decision in February, and that's really no surprise, it's a big fine. But they said that they had worked hard to create a transparent and straightforward approach to consent, and they said that consent's actually really easy to give. No surprise that the French regulator did not agree with that assessment, and they said, no, it doesn't comply because it's not specific and it's unambiguous, and the consent for personalised ads, it's a checkbox and it's ticked by default. So the French regulator also said that Google had buried its policy around this issue amongst other terms and conditions. So you had to click through a number of pages before you had any understanding of how your data was being used to personalise ads. It's a case to watch because we probably won't see a decision from the European Court of Justice for another 6 to 12 months. So something to watch to see whether or not that fine actually sticks. Mistake or ignorance has no bearing on the fines that will be issued. A hospital in Portugal was fined €400,000 because its account management practices were deficient. So it had almost 1,000 active accounts, but only 300 doctors working for it. Any doctor had access to all patient files, irrespective of their speciality. And the hospital said in that case that we're not responsible for this because all we've done is simply employ the same IT system that's been implemented by all public hospitals in Portugal. And the Portuguese regulator said, no, it's your responsibility, the hospital's sole responsibility, to ensure that they have adequate security measures in place. They couldn't point the finger and rely on the public system. It really needed to take responsibility for its own systems. Attempting to avoid large costs for non-compliance is a big no. Case in point, a Polish marketing and analytics company was fined €220,000 after it failed to notify 6 million data subjects on the basis that to do so would have cost €8 million. So their position was that they'd have to notify these people by post or by telephone, and the cost of doing that were disproportionate. And they had notified those data subjects for whom they had an email address, But the Polish regulator said that in this case, your infringement of the GDPR is intentional. You know what your obligations are. And so in those circumstances, it did impose a larger fine than would have otherwise been the case. And finally, data subjects have a heightened awareness of their individual rights under the GDPR. That's no surprise given what types of complaints the regulators are experiencing at the moment that focus on access rights and the right to be forgotten. Territorial scope on the GDPR is still an issue that Australian organisations are really grappling with, and that's no surprise. Somewhat helpfully, the European Data Protection Board released some draft guidelines at the end of last year. They were open for public consultation until January this year, so we expect to see the final version released sometime soon, but there are some key takeaways to take from those draft guidelines. Firstly, the fact that an Australian organisation doesn't have a branch or a subsidiary in the EU doesn't preclude it from having an establishment there within the meaning of the GDPR. So there's a threshold test for determining this, and that's whether or not there's a stable arrangement in place. So in some circumstances, a single employee or agent of the Australian entity may be sufficient to constitute a stable arrangement. But it can't be too broad. So an Australian entity that simply has its website accessible by people in the EU won't be enough to satisfy the test. The requirement that data subjects be located in the EU, that issue must be assessed at the moment when the relevant trigger activity takes place. So at the moment of the offering of goods or services, or the moment at which the behaviour has been monitored. So what's relevant is the stage at which you're collecting their data. And thirdly, processing personal data of an individual in the EU alone is not sufficient to trigger the application of the GDPR to Australian organisations that aren't established there. So there needs to be an element of targeting the individual. So if an Australian citizen is travelling through Europe on holiday and downloads an Australian news app, for example, and the app is exclusively directed to the Australian market, then in those circumstances, the Australian company won't be captured. There are a number of misconceptions under the GDPR. The first, which I touched on before, which is that consent is the only lawful basis for processing data. There are 5 other lawful bases for processing data, so no single one is better than the next. But whichever one you decide to adopt, you really need to incorporate that into your privacy policy. Breaches will result in huge fines. Not really the case. The fine that's been issued to Google is the highest yet, but it's only 0.5% of Google's global annual turnover. We're also seeing some fines at the lower end of the scale. So the Austrian DPA issued a €4,800 fine last year for monitoring a public space without proper transparency because video surveillance hadn't been adequately marked. Small businesses are exempt. Not true. There's no monetary threshold like there is under the Privacy Act. And all businesses require a data protection officer. Again, that's not the case. A number of small businesses may be exempt from that requirement. You're only required to have one where you're a public authority or where your core activities involve large-scale or systematic monitoring of individuals or processing of special categories of data like criminal convictions and offences. Now just on to some key trends that we've identified from the matters that we've been involved in the Australian space. The first of which is a number of organisations prematurely notifying the OISC. And this can cause some major issues down the line. But what we're finding is, as before we're appointed, an organisation is concerned about the timeframe under the Act, which they should be. They notify before completing an adequate forensic investigation. The forensic vendor comes in and has a look and decides, actually, there's been no unauthorised access to personal information. So in those cases, there's been no need to make a notification under the Act.
Another area, and probably referred to this earlier, is deficient notifications that aren't handled very well. I'm sort of harping on about it a bit, but the effective risk of harm management and assessment is one of the key areas. A notification that can't provide some guidance about potential harm is a deficient notification. Notifications that don't adequately provide pathways for effective actions for individuals aren't very useful, and those are emotive and using or blaming of other parties rather than just sort of shouldering the blame and moving on with solutions. I've also referred to dual notifications and the importance to notify if you're the party that has the most direct relationship with the individuals impacted.
There's certainly some confusion around compliance, so a number of organisations that are in fact captured by the Privacy Act aren't complying. We're also noticing with a lot of ransomware incidents that the organisation focuses on getting things back to normal, looking at business interruption losses, but they fail to consider what level of access there may have been before the ransomware was deployed. So something to think about in those cases.
This is an ancillary point. But there's no sort of regulation that comes into effect that doesn't create work for lawyers, and this is no different. Recoveries are something we're seeing becoming a factor where there are actions against IT vendors who fail to identify vulnerabilities, for example, in a system that's led to a data breach, or whether they fail to properly back up systems. So after a ransomware attack or whatever, it's been costly to put the company back in place where it was before. We're seeing a lot more litigation around that. I think we'll see a lot more. It usually follows a data breach, but it's something to keep in mind.
We're certainly seeing the long tail claims risk arising from data breach notifications. So individuals that have been affected are seeking compensation, they're making complaints, they're asking questions about your information security practices. We're also seeing a lot of third parties making freedom of information requests to the OIC in relation to a notifiable data breach. So that's something that we're dealing with on a day-to-day basis also.
The issue of cyber insurance is an important one. It forms a part of a lot of organisations' answer to cyber threats. In the utilisation of that insurance cover, we've seen a few issues, a failure to notify insurers early on. Often these policies provide quite effective assistance immediately after a data breach has occurred, and that's not always being well utilised. It's important as an organisation to know what your cyber insurance cover provides. There are very different wordings. Social engineering is included in some, it's excluded in others. And when you see the amount of phishing that's occurring and other social engineering attacks, you've got to make a judgment of whether that's important for your organisation.
And certainly there's an increase in complex data breaches. So Office 365 attacks, whilst the attack vector might not be overly complex, what is difficult is working through the personal information that's been affected. So looking at, say, for example, 5 mailboxes that have been affected, which categories of individuals do we need to notify? I won't go through these slides, but I understand you'll receive a copy of them. So they're just some key points around some issues we've identified in BEC incidents and also in ransomware. How can you prepare? I don't propose going through this either. I think I'll be preaching to the choir here, and I'm sure a number of you are already well advanced in these issues. Our future trends and issues, there's certainly some changes to legislation which I touched on before under the Privacy Act. There's a new APRA standard which will commence in July, which will require APRA regular entities to notify APRA within 72 hours of identifying a breach. Changes in attack vectors are something we need to keep an eye on. Threat actors are always getting better at this. Phishing attacks have become more sophisticated and harder to detect. So that's something. It's just keeping in touch with the whole development of attack. Critical infrastructure risks, that's something to watch. The US experiences that threat actors are certainly looking at this area now. We've seen what's happened in Ukraine where threat actors have been looking at wiping out our energy grids, so something to watch. AI is going to become an increasing issue, and with AI, the whole consent model we've been talking about, when you consent to your individual information, your personal information being used, in an AI environment, do you know how that's going to be used? Sometimes the organisations that are using it don't know. So we can see maybe that consent model will change and that'll be addressed over time. Individual rights to privacy, unlike in the US or the UK, we currently have no tort of privacy in the common law in Australia, but that possibility of it occurring could change, particularly having regard to the current case law around the issue. So if that happens, then there's a possibility of civil litigation based on an accepted tort of privacy. So that will represent a significantly new risk to Australian organisations that are affected by a breach. Surveillance and use of CCTV has been a hot issue in Europe. The Queensland Law Reform Commission is currently looking at that very issue here and undertaking a review of surveillance laws, both in the civil sphere and the workplace environment. The Commission has been tasked with drafting legislation, and we expect something at the end of October in terms of that analysis. And just finally, in Queensland, there's been the introduction of the Human Rights Act, which applies to the government sector, but it introduces a general right to privacy. So now individuals will be able to make complaints to the Human Rights Commissioner, for example, if they're concerned about local councils setting up cameras, for example. So I think that's all the time we have. Thanks very much for your attention.
Thanks, Matthew and Stephanie. Thank you for taking us through the OIC and the EU's GDPR reports.